Hi, I'm Alexander Haberbush, Executive Director and a Constitutional Attorney here at the Lex Rex Institute. Let's say someone told you the Supreme Court had just come to a narrow decision, 5-4, on a controversial case involving the rights of a Native American nation, and for which a conservative justice had written the majority opinion. What kinds of assumptions would you make about that decision? Would it favor the Native American side, or not? Well, exactly one such case wrapped up a bit less than a year ago. The case was McGirt v. Oklahoma. The majority opinion was written by Justice Neil Gorsuch, and the result may surprise you, but it shows us something very important about our legal system. The finer details of the case are a bit too involved to go over in full in this video, but here are some of the basics that you need to know. Jimcy McGirt, a Native American man, was accused of serious crimes and sentenced by Oklahoma state courts to life in prison. McGirt filed an appeal, arguing that Oklahoma couldn't try him in the state courts because the crimes for which he'd been accused had taken place within the Creek Reservation, a reservation that had been granted by a treaty with the United States. McGirt and his counsel argued that his convictions in the Oklahoma courts weren't valid, because existing law holds that when tribal members commit certain crimes on reservation lands, they can only be tried in federal courts. Oklahoma countered, saying essentially that the reservation had been extinguished and that Oklahoma now had jurisdiction over that land, and therefore McGirt could be convicted in Oklahoma state courts. It gets a bit more complicated than that, but I think that'll do for a rough outline. Now, if you've absorbed enough of the kind of legal commentary that most of the major media outlets like to engage in, you'd probably expect the conservative justices to just side with Oklahoma's argument in this case. It's become almost a commonplace that politics, in general, but especially conservative politics, really amounts to more or less naked attempts to cater to particular interest groups. It's also become the received wisdom to believe that judicial rulings are just an extension of politics. So typical Americans would probably assume that right-leaning judges would side against a Native American tribe, especially when the other party is the government of a reliable red state, and the petitioner is a convicted criminal trying to get off on a technicality. But isn't this all a bit cynical? And what's more, isn't it a bit conveniently cynical? Cynicism in the law can be a self-fulfilling prophecy. If you go into the law believing the courts only ever rule on the basis of their political preferences, well, it helps you justify shaping your legal arguments to match your politics. In the meantime, it lets you off the hook from actually doing the hard work of legal interpretation. It's a little bit like, say, playing fast and loose with the rules of Monopoly. If you assume everyone else is cheating the system, you feel better about doing the same thing. You may even insist on being the banker just so that you can cheat more effectively, telling yourself that you're only leveling the playing field. But at that point, why play the game? It means nothing any longer. You just end up stripping out all the elements that make it a game. The dice rolls don't matter, the rents you collect don't matter, the other players don't matter. You just pay yourself and try to avoid being caught. Well, that's exactly what happens when Americans start viewing the law as just an extension of the political process. We try to get the outcomes we want, even if the rules say otherwise. Even the fact that we routinely refer to some of the Supreme Court as conservative and some as liberal or progressive is a very bad sign. Control over the court becomes just another political goal, making certain presidential campaigns more important, since the president gets to nominate justices to fill any vacancies. You'll probably remember that this was a major talking point in both the 2008 and the 2016 elections. Now, no one is denying the Supreme Court certainly has on occasion reached decisions that seem to be rooted far more in political conviction than constitutional interpretation. There have been more than a few of them. But that's part of the same self-fulfilling prophecy. The justices may very well believe they're simply playing the game by its unwritten rules, and that's a point of view that a huge number of American voters have implicitly endorsed. Simply put, the American people have told the justices to do this. On the other hand, if McGirt v. Oklahoma demonstrates anything, it's that this cynical understanding of the judicial process is not the only possibility. Gorsuch's opinion makes the, in our view, impeccable point that the legal principles involved are at heart actually very simple and easy to interpret. The Constitution grants Congress the exclusive power to regulate commerce with foreign nations and among the several states and with the Indian tribes. Congress granted the Creek lands in Oklahoma for a reservation. They never reversed or modified that grant. Consequently, the Creek's jurisdiction over the land continues, and Jimcy McGirt's argument is correct. The state of Oklahoma has no jurisdiction over his case, which is exactly what the court said in its majority opinion. In essence, Oklahoma's argument, which was taken up by Chief Justice John Roberts in his dissenting opinion, was simply that Oklahoma had, for decades, practically speaking, acted like it had jurisdiction over the territory. It had established courts for the area, made laws, enforced those laws, and in general treated it as anything but a Creek reservation. As the Chief Justice put it, the decision in favor of McGirt and the Creek Nation creates significant uncertainty for the state's continuing authority over any area that touches Indian affairs, ranging from zoning and taxation to family and environmental law. Simply put, Oklahoma tried to make a legal question into a pragmatic one. They didn't ask, what does the law say, but rather, won't following the law cause problems? And some of the justices bought it. Gorsuch's opinion, on the other hand, is a beautifully expressed statement in favor of letting the law be the law. It's one that's so well expressed and such a clear statement of our philosophy here at LRI that we hope you'll forgive us for quoting it at length. Today we are asked whether the land these treaties promised remains an Indian reservation for the purposes of federal criminal law. Because Congress has not said otherwise, we hold the government to its word. We do not pretend to foretell the future, and we proceed well aware of the potential for cost and conflict around jurisdictional boundaries, especially ones that have gone unappreciated for so long. But it is unclear why pessimism should rule the day. The federal government promised the Creek a reservation in perpetuity. Over time, Congress has diminished that reservation. It has sometimes restricted and other times expanded the tribe's authority, but Congress has never withdrawn the promised reservation. As a result, many of the arguments before us today follow a sadly familiar pattern. Yes, promises were made, but the price of keeping them has become too great, so now we should just cast a blind eye. We reject that thinking. Unlawful acts performed long enough and with sufficient vigor are never enough to amend the law. To hold otherwise would be to elevate the most brazen and long-standing injustices over the law, both rewarding wrong and failing those in the right. We concur wholeheartedly with this sentiment. The American people should never be afraid to let the law be the law. No other consideration, whether political or even pragmatic, should be allowed to overrule constitutionally enacted law. America is, after all, a country that believes firmly in self-government. If enough of us believe the law should be changed and vote accordingly, it can be. Until then, we have no excuse to ignore it.